All right, hello, ladies and gentlemen. I'm back. So while I was out in the woods, I figured it would be a good idea, especially since some people rely on having an actual lecture when they come to class, if I run through the lecture portion while I'm here. I know the lighting here stinks, but you're not going to be watching me because I'm going to share the screen and pull up the PowerPoint and go through. This is chapter 5 and 6 in your textbook. So we're going to be talking about judges, how judges are selected, misconduct of judges, how judges are supposed to do their job, what the federal system requires. Then we're going to talk about juries. Again, how juries are selected and all of the ramifications around juries, which are the topic of your discussion question number 2 for this week. Okay, so let's take a look. Let's roll. I'm going to share the screen, and we'll bring up the PowerPoint, and hopefully we can jump right into showing the PowerPoint. There we go. So again, we're judges and juries. We're in chapter 5 and 6 in your textbook this week. Judges, you have many different types of judges. We already talked about the different types of courts, so you should have an understanding that obviously if you have a different type of court, you have different types of judges. You have judges in the state system, judges in the federal system. You have judges that are elected and judges who are appointed. You have judges with very minimal training. As an example, Philadelphia Traffic Court, which has since been disbanded. These people were elected and did not have to be lawyers, did not have to have any training whatsoever to be a judge. So they don't all have legal expertise. On the other hand, when the president appoints someone to the Supreme Court of the United States, it's expected that that person have a lengthy history of judiciary experience. So obviously they're lawyers. They've already served, for the most part, in courts, although not all of them have been judges before. We have had presidents who appointed lawyers who may not have ever been judges. But a lot of times you're looking for people who have been judges, usually in the federal system. So someone who was previously appointed, maybe by a previous president, might be then appointed as President Trump recently appointed Neil Gorsuch to the Supreme Court, and he was previously a federal circuit court judge in one of the many circuits around the country. As you know, there are 13 circuits. We covered that. It's in your textbook. We covered that in class as well. So keep in mind, they come from a variety of experience. Again, not all judges have experience as prosecutors or defense attorneys. So the interesting thing, you might have someone who's assigned to a criminal court who has never been involved in a criminal case, but now they're the judge, and their job as a judge obviously is to rule on the law. Judges obviously have different personalities, just like anybody else in any job. You can have different personalities, different ideologies. Some have prejudices. Unfortunately, we can't escape the fact that there are prejudices amongst people within our country. But all judges are bound by certain rules of law. So if they do not follow the law, there are repercussions for that. Well, so how do we select judges? Well, politics, unfortunately, plays a significant role sometimes in how judges are selected. Whether they're appointed or they're elected, there's some type of political thing going on. As anybody who followed the recent selection of Justice Gorsuch to the Supreme Court knows that there were a lot of talk between Republicans supporting him, maybe Democrats not supporting him. Sometimes the politicization is not about whether the judge is good, but it's whether the one side or the other likes the president. So you have that issue. So they might refuse to, maybe you have the Senate who has to approve these candidates for federal positions who may not want to do that because they don't like the person who's the president of the United States. And it may not have anything to do with the judge themselves. You recall under President Obama, he made an appointment and the Republicans refused to even have hearings. So there was politicization. So some people would say, hey, that guy should have been the judge. He should have been the most recent justice of the Supreme Court, but because the Republicans would not allow a hearing, that gentleman never got the job. And then new president comes in, appoints his own guy, who he looked at for maybe his values, his positions, whatever, and appoints him. And then, of course, the Senate confirmed him. So politics definitely has a play in this particular thing. Unfortunately, when politics is a dominating factor, candidates' qualifications sometimes are irrelevant. Sometimes. I wouldn't say, as the slideshow does, practically irrelevant, but as in the case of the gentleman who was appointed under Obama, and unfortunately I don't remember his name, but his qualifications were stellar. He had tremendous qualifications, highly qualified. If there was a different political environment, he probably would have got the job. But because of the political environment, it didn't matter how qualified he was. In the states, how do we select judges? And we already talked a little bit about the federal system. We're going to talk more in a moment. But judges are either appointed or elected. Depends what state you're in. And I put in a discussion for you to find out, how are the judges selected in the state that you live in? Because usually it's uniform throughout the state. So if you are someone in the city of Philadelphia, you would know how judges get their jobs in the city of Philadelphia. Probably. Although not everybody's up on their civics. Maybe you don't know. Find out. And I want to see it in the discussion. So we have 5 ways that judges are usually selected. It's going to be a partisan election, which means they're going to run as a Republican or a Democrat or some other political party. A nonpartisan election, which means that they don't attach themselves to any kind of political party. You have a gubernatorial appointment, which means that the governor, gubernatorial refers to the governor of the state. The governor is going to make that appointment. Sometimes it then has to be confirmed by the state senate. And you have a legislative appointment, which means your state legislature makes the appointment. And you have merit selection. We're going to get into what that is a little bit more. And of course, it's in your book, which you should either be reading or have already read and know these concepts. So partisan elections, judges are the same as elections for other offices. They run on a party ticket. The public votes for their choice by secret ballot. You go on election day. If you live in an area where judges are elected, and I'm not telling you where because I want you to find out for yourself, then you're going to go in that voting booth and you're going to choose judges. Those places that have judges up for election, that means that you have a lot more people on your ballot than places that don't have judges up for election. So you're going to make that choice. Judges serve a term of years, sometimes 4, sometimes 6, sometimes less. Again, it depends upon the state. Usually it's around 4 years. All right, in nonpartisan elections, they don't run with any political party. As I said, they're put on a list and people vote. And there's 14 states that do this for their appellate courts. Most popular are not necessarily the best candidates will fill your position. There's a problem there. If somebody does a really good job in an election, if you're electing judges, they do a really good job of putting themselves out there. Maybe they get elected and somebody who's really, really qualified doesn't get elected because they didn't do a good job campaigning. Great example, Philadelphia Traffic Court. I said traffic court no longer exists in Philadelphia, but there was a guy who ran for traffic court several years ago who had, I think, 100 to 200 pending traffic tickets that he never paid for. And he wound up being a judge on traffic court. I mean, it's absolutely crazy. But, when you're running for office, you don't tell anybody about your history, and apparently nobody found out until after he got elected. Voters rarely know what the judge thinks. When they're running for office, you don't know what the judge thinks. What do they think on crime? What do they think on the death penalty? What kind of sentencing are they going to do? Are they going to be very harsh? Are they going to be very lenient? Are they going to be the guy who takes a child molester and sends him to 6 months probation and everybody's going to get mad? Or are they the guy who is going to take the person who's speeding and suspend their driver's license and everybody's going to get mad because it was too harsh? You never know what they're doing if you're electing these judges because they don't tell you. Usually some amount of private financing is behind each judicial candidate, so that's an issue as well. Who's paying for the judge's campaign? Who's behind that? Is that judge then going to favor those people if they come before him or her in court? And you never really know. There are reporting requirements for elections, but you as the general public, when you're electing, you don't know who's paying for that judge's campaign. Gubernatorial appointment, again, means the governor appoints the judge. Some states use legislative appointment, where the legislature votes to seat judges. Problems with appointments. We said there's problems with electing people, but there's also problems with appointments, because if the governor is going to appoint somebody to be a judge, who are they going to appoint? Are they going to appoint their friends? They're going to appoint somebody they used to work with? And that happens. In my state of New Jersey, where the governor appoints the Supreme Court, generally they pick somebody that they know and they like and they work with. Not always. Governor Christie in New Jersey has appointed both Democrats and Republicans to judicial positions within the state. So, pretty balanced that way, but sometimes, it's all about who you know. So maybe they're not learned in the law. If you pick somebody who is your buddy but happens to be a lawyer and he fills the bill, the governor or legislature appoints a person who will best forward a political agenda. That could be a problem. If you pick a guy because they're going to help you out politically, maybe that's not good for the community. You might also have gender or racial bias or lack of diversity. If the governor is a white guy and he only picks white guys, never picks any females, never picks any Asians, never picks any black people, Hispanics, whatever, could have that problem. Now, today, our society is so open and people are watching everything. Maybe that's going to happen less, but it still has potential to happen, especially in lower court picks. Merit selection is a system where you have the governor or the legislature may be the final stamp on it, but you have a nominating committee that selects a list of candidates based upon their merit. What's their experience? What's their training? What have they done? And then that list is given to the governor or legislature for decision making. You also have that happen sometimes in re-elections. Any appointed judge seeking re-election will run on the basis of their merit, and not necessarily a political affiliation. So the judge, somebody who's running for a Supreme Court in a state where they're elected, might say, well, I was a judge in magisterial district court, I was a judge in common pleas court, and this is my legislative record, or my court record, my judicial record, and you should put me in the Supreme Court because when I was in common pleas, I put a lot of bad guys into prison, I did this, I did that, and they're going to run on their record rather than the fact that they were Democrat or Republican. Federal judges. How do we get federal judges? I mentioned it already, so you should know. Think in your head. Do you know right now how are federal judges? Are they appointed or elected? Anybody? Were you right? They're appointed. Who appoints them? Think about it. Give you a second to think about it. Who appoints them? The United States president. Were you right? Well, now you're going to remember. So if we ask you again later on, or it's on a quiz for this course, for this week, you're going to know the answer. Federal judges are appointed by the President of the United States. Is there any approval needed after the President selects them? I already mentioned this earlier in this lecture, so you should know the answer. Who is it that has to approve? Is there an approval needed, and who is it? Well, yes, and it has to be the Senate. And that's pretty much with any presidential appointment, whether it's the cabinet or a judgeship, Supreme Court, whatever, the Senate of the United States has to approve it. Now, who knows how many senators are there in the United States Senate? Give you a second to remember. Anybody know? There are 100 senators in the United States Senate. Why are there 100 senators? Because there are 2 from every state. 2 senators from every state, which means, how many states are there? I hope you know. There are 50. So if you have 50 states, you have 2 senators from each state. That means you have 100 senators. Anybody know how many Congress members there are? I think it's like 435. And that's based upon the size of the state, the population of the state. So larger states have more, and that's part of, and it's not a social studies class, but we have that split type of legislature so that no one state has the most amount of power. Same reason why we have the selection of our president through the system that we use that people don't seem to like, where you have the electoral college actually selects the president rather than the vote of the people, and that's history lesson. All right. So U.S. magistrates are appointed by the U.S. District Court judges. Magistrates, as you remember, when we talked a few weeks ago, were created in the 70s, I believe it was, to take some of the workload off of the district judges. So the president doesn't appoint them. The district court judges appoint them, and they do arraignments, preliminary hearings, they sign off on warrants and those kind of things. They don't do trials. The district court judges do the trials. But the magistrate court judges are appointed by the court judges itself to do some of those administrative functions. Federal court appointments, judges are lifetime appointments, so keep that in mind. You know, if somebody's appointed to the United States Supreme Court, they are a judge for life. If they're appointed to the district court, they're a judge for life. The circuit court, judge for life. And this can be good, it could be bad. I've heard stories, those of you who were in class last week, prior stories from our friend Nicole, who came to visit us last week, about judges who have been on the bench for so long and they're so old that they fall asleep during trials. Kind of scary. Look at our Supreme Court, U.S. Supreme Court, those people usually stay for life. Just a few years ago, Sandra Day O'Connor decided to retire. They can do that. They can retire. But their job is for as long as they want it. So you could have somebody 91 years old, 100 years old being on the Supreme Court if they live that long. And if they're getting tired really quick, maybe they're not doing a good job for us. Who knows? But if they're still able to do the job, sure, have at it. But it's something that has its good points and its bad points. The good point is, obviously, if somebody's appointed for life, they are not subject to the political whims once they're appointed. Because nobody can get rid of them, unless, of course, they do something corrupt, misconduct. So once they're there, they're there. They don't have to worry about who the president is this month or this week or this year. They're going to do their job either way. So they are often reflecting the president's vested interest, the president that they are appointed, because that president, when they appoint somebody, just as, like I said earlier, President Trump recently supported Neil Gorsuch. One of the big issues that every time somebody appoints a Supreme Court justice, they're talking about the abortion issue and Roe versus Wade. Conservative Republican folks would like Roe versus Wade to disappear. And of course, our liberal Democrats would like it to stay. That's the Supreme Court ruling from the 70s that allowed abortion. So every time a conservative president gets to appoint somebody, they're looking for somebody who might consider repealing Roe versus Wade later on. That's just a fact. And they know that the more people they can appoint to the Supreme Court, the more they might be able to sway the court towards their own political thing. One thing I'm sure most of you don't know, Franklin Roosevelt, when he was president, he served almost 4 terms before they put in the amendment to cut the terms back to 2. Franklin Roosevelt tried to increase the size of the court. He tried to add more justices to the Supreme Court. Legislature shot him down, the Congress shot him down, but he wanted the ability to appoint more judges, basically so he could get his own way. So, and that's what presidents will tend to do, is try to appoint people who have the same interests, the same values as they do, hoping that they will then vote in their favor on issues that come before them. Just as President Trump is hoping that with Neil Gorsuch recently appointed to the Supreme Court, that when his travel ban goes before the Supreme Court, that will be a vote in his favor. So we'll see how that goes. They're not supposed to even hear it till November. if the travel ban will probably be over by then, if it's going on right now, because it was only supposed to be, I think, as much as 180 days. So, but again, if a president gets to appoint judges, they're going to appoint somebody who thinks the way they want them to think and made decisions in their favor. So they want to have their social agendas move forward. No uniformity in training among judges throughout the country, lower courts and state courts. Qualifications for state judges are diverse. In other words, in Indiana, there might be a requirement that somebody be a lawyer and have several years in a lower court before going to an appellate court, where maybe in Illinois, they don't have the same requirement. And I don't know the requirements for those states off the top of my head. I'm just using those states as an example, because I don't want to tell you what's going on in PA or New Jersey, because I want you to look it up for yourself. But there are different standards that exist for selecting judges to determine their qualifications to serve in judicial positions, and of course, compensation and retirement. So there's a lot of issues, and they're different across the states. There was an issue in New Jersey just a couple of years ago because of how Governor Christie wanted to change the pension system. And judges were really upset because some of them were going to lose money in their pensions because of the changes that the governor was going to make, because the judges in New Jersey are part of a state-funded pension system. Judicial misconduct. Judicial conduct is monitored by different persons, organizations among jurisdictions. So there may be a judicial, like maybe the Supreme Court. In the state of Pennsylvania, if I remember correctly, the Supreme Court is responsible for monitoring the conduct of all of the lower court judges. So if somebody in say Bensalem, one of the district judges in Bensalem, violates the rules, it's going to be the Supreme Court that's going to provide that judge with some consequences, going to investigate it and then do whatever they do. Some forms of misconduct. What could a judge do that would be considered misconduct? They may be prejudiced in their evidentiary rulings. So maybe they allow evidence in cases for people that they like, or maybe certain types of people that they like. If there's bias or prejudice going on, that could be misconduct. Deliberately aggravate or mitigate sentences. So maybe in some cases they provide a harsher sentence. Could it be based upon race, ethnicity? Would it be based on gender, where a judge, gives every white guy a break and every black guy goes to prison? Is that possible in our society today? It still is, unfortunately, but that would be judicial misconduct. Because obviously, if all the circumstances are the same and the person, their conduct is the same, obviously there's going to be things in their background, and the judge should use the facts to determine what the sentence is going to be. But if they base their decision on things like race or gender or ethnicity, that would be inappropriate. All right, accepting bribes. There have been cases where judges accepted bribes in order to make decisions in the favor of people. This case mentioned in 1978, Operation Greylord, you had 60 judges convicted of judicial misconduct in Cook County, Illinois. For those of you who don't know, Cook County, Illinois is where Chicago is. So, and also if a judge commits a crime, that's misconduct. And just like if you're a police officer or you're a prosecutor, being a judge, if you commit a crime, is one way that you could lose your judgeship. Unfortunately, we are not very good in the United States in punishing these people for their misconduct. Just like we noticed with prosecutors, sometimes we don't have a lot of good accountability, and we don't catch these people, we don't sanction them. There are some really interesting cases in the state of Pennsylvania. A number of years ago, in one of the counties in Pennsylvania, there was a juvenile court judge and the chief judge who both went to prison because they were making decisions. The one judge was making decisions in juvenile cases to send juveniles to this for-profit detention center that the county was paying for, but the judge was also receiving a kickback from the people that owned the detention center. And the chief judge was aware of it. I believe it was Lycoming County. You could look it up. But yeah, these were two judges that actually went to prison for misconduct in the state of Pennsylvania. So it does happen, but point is, sometimes judges get away with stuff. Whenever corrupt or incompetent judges are identified, there are relatively few mechanisms available. One of them is impeachment, just like if the legislature will then have what's just like a trial to remove someone from office. And, the impeachment was talked about. There was actually a Pennsylvania Supreme Court justice a few years ago who was involved in some misconduct. And impeachment was talked about in that case. I believe she resigned. I forget the exact case. I didn't research it beforehand. But Pennsylvania has a lot of stuff going on in the past with regard to these people. If they're elected, sometimes there's the ability to have a recall election where the people would vote to remove them from office, just like they voted to put them in office. That's what a recall election is. So impeachment means you allege the wrongdoing against a judge before the legislative or judicial body. So the judicial body, it might be the state Supreme Court, like I said, in Pennsylvania, might have their own trial and hearing before their court and decide to remove the person from office, or it might be the state legislature. In order for impeachment to be successful, allegations must be well-founded and upheld by compelling evidence against the accused. Many jurisdictions, the state Supreme Court is the sanctioning body that hears impeachment allegations. Recall elections, like I said, people circulate a petition, interested citizens, and then their special election is held, and the vote determines whether the judge is removed from office or not. Juries. Anybody served on jury duty? Anybody had the great luck to be on an actual jury in a criminal or a civil case? States have similar guarantees of a right to trial by jury. In our federal system, it's under the Sixth Amendment. In the state system, obviously the Sixth Amendment holds true, but you also have the states have their own rules. This right is not applied to all criminal prosecutions. Supreme Court consistently excluded petty offenses from this right. So if you go to traffic court, well, Pennsylvania doesn't have, or Philadelphia doesn't have traffic court anymore. But if you go to Philadelphia Municipal Court for a traffic ticket, or you go to one of the municipal courts in the state of New Jersey for a ticket, or the magisterial district court throughout the state of Pennsylvania, you will just have a judge or magistrate hearing your case. You won't have a jury. So you don't have a jury in minor cases around the country. States are not bound by the Sixth Amendment jury guarantee until 1968 in the case of Duncan versus Louisiana. The accused may also waive the right to a trial by jury in favor of a bench trial. Bench trial means that a judge will hear the case and not a jury. Or they could waive the jury trial if they have a plea bargain. So there's two ways that someone could say, I don't want 12 or 6 people to judge me. I just want the judge who is experienced in this to judge me. Or I'll make a deal with the prosecutor and I will plead guilty to a lesser charge and I'll agree to take this particular sentence. Those are two ways that you could get out of a jury trial. Jurors, like judges, are supposed to be impartial. They hear the facts of the case and they base the guilt or innocence only on those facts. They're not supposed to judge people based on race or ethnicity. They're not supposed to be judging it on what the public outside the courtroom feels. The jury acts as the conscience of the community. They're supposed to safeguard against corrupt or overzealous prosecutions and biased judges. So the idea is that so someone's not railroaded, it's an old term, railroaded through the court system by a biased court or biased judge or a biased prosecutor. We have 12 citizens generally who are supposed to be your peers who hear all the evidence and then decide whether or not you're guilty or not guilty. You look at the case of Bill Cosby just recently, you had 12 people there who couldn't come up with a decision one way or the other. I think it was like 10-2 or 11-1. So that was a hung jury. They couldn't come up with 12 people that said he was not guilty or 12 people to say that he was guilty, which obviously was good for him. He would prefer to be not guilty, but even having a hung jury means that he's not going to prison right away. And if the Bucks County prosecutor doesn't decide to prosecute, or I'm sorry, Montgomery County prosecutor doesn't decide to prosecute, maybe he doesn't have an issue at all. The jury is also the defendant's protection of life and liberty against prejudice. Jury decisions throughout history have caused some to question the integrity of the jury system. You have issues where you have people who most people would say, hey, he was clearly guilty, and yet the jury decided to let him off. Or maybe somebody who really was innocent or looked to be innocent, and the jury convicted him. Yeah, I don't know what happened here, because I was already here. I lost my connection for a second, I guess. But to see how that happens. So in the O.J. Simpson trial, as you may recall, O.J. Simpson was found not guilty by a jury of his peers. And a lot of people to this day believe that he was, in fact, guilty. And because of whether it was racial or whether it was because the prosecution did a bad job, whatever reason it was, he was not convicted. And of course, later on, he was convicted in a robbery charge in Las Vegas, and he got like a 33-year sentence. And some people say that the judge in that case sentenced him harshly because of the previous, getting off from the murder thing. Now, recently, you may know in the news, he was given parole. So he'll be getting out pretty soon. So he served like 8 or 9 years, I think, on that, and the parole board decided to release him. So very interesting. Grand juries. Grand jury are people, remember we talked about preliminary hearing or grand jury. Those are the people who are going to decide whether there's enough evidence to determine whether you should go to trial or not. This is just a little bit about the history of it. You can read that in the book. Usually you had judges traveled the circuits, and grand juries helped to gather information about criminal activity and present that information to the judge when the judge came to their town. Petit jury, that's the name of the jury that hears the case in a criminal trial. So the grand jury is 24 people usually that hear evidence to determine whether somebody goes to trial. We talked about this already in a previous lecture. And the Petit jury, they are the ones who actually hear the criminal case and decide whether someone's guilty or not guilty. It replaced trial by ordeal somewhere after the signing of the Magna Carta, reduced the king's power, and provided foundations for due process and the right to a jury trial of one's peers. That was the Magna Carta. Also in 1215, the withdrawal of the church, this is the Catholic Church, if you don't know what it's talking about, from the trial by ordeal, the started the existence of the Petit jury. Jury members in the medieval jury were expected to have some knowledge of the case, and they weren't impartial. So unlike our juries today, when they brought jury members in these cases, they actually knew something about the case beforehand. All right, how do we select a jury? This is important to know. If you've ever had jury duty, you might have a clue. But they have something called the veneer. The veneer is a list of qualified jurors. So if you registered to vote, if you've got a driver's license in most states, you're going to wind up on a jury list. You'll get a little card in the mail, and they ask you some questions and determine whether you're eligible to be a juror. So how do we do that? You have a short questionnaire. They want to know if you're a citizen or you're at least 18 years of age, mental or physical disabilities, ever been convicted of a felony. So if you give the right answers to the question, then you're eligible to jury. In some states, there's some exemptions. Like there used to be an exemption when you were like a volunteer firefighter or emergency medical person or a teacher. There's a lot of exemptions. They've cut back on the exemptions because too many people weren't serving jury duty. So like my wife's a teacher. If you are a teacher and you are selected for jury duty in the state of New Jersey during the school year, you tell them I'm a teacher and I have to be in the classroom, they won't get you off. They'll tell you, okay, now you got to reschedule it for the summertime when you don't have school. So it's a little bit hard. It used to be that you could just say I'm a teacher and I don't have to be on jury duty, or I'm a firefighter, I don't have to do it. Now, a lot of times they reschedule you. All right, voir dire is a process of determining a person's appropriateness or worthiness to serve as a juror. So this is where you're going to have the prosecutor or the defense attorney trying to get the people that are best for their case, and they want to get rid of any people that might be biased one way or the other. They want to make sure we have a fair trial, so they want to get rid of any biases. They don't really want people that have knowledge of the case, preconceived notions, already made up their mind. They want to check on the attitudes. Like if it's a death penalty case, obviously the prosecutor wants people that are going to say, yeah, I would have no problem deciding on death penalty. They don't want people that are squeamish or saying, no, I could never do that, where, of course, a defense attorney is looking for those people. But they do want to try to see if they understand laws and statutes so that they know that when it's explained to them, they'll be able to make a proper decision. During that voir dire process, the lawyers have two ways of challenging jurors. There's challenge for cause or preemptory challenge. Challenge for cause is if somebody doesn't meet all the requirements. So if they answered that questionnaire and they lied, and the attorneys can point that out, they can get rid of them. If they could show somebody has a bias, they can get rid of them. If there's another valid reason, they can get rid of them. The preemptory challenge, you don't have to explain it. So the DA decides he doesn't want Joe Smith on the jury, he doesn't have to save it or explain it. They have a certain number. It might be 4, it might be 5, and they can get rid of those numbers of people from the jury pool. Of course, they cannot be used in a racially discriminatory manner. So you can't have a prosecutor who is removing all the black people from the jury pool for a black defendant because he wants the white people to find him guilty. Not allowed to do it that way. And that was decided it took till 1986 for a court to decide that, which is crazy. But sometimes things take a long time. All right, jury consultants. This is a big business nowadays where you have people coming in and trying to help attorneys to decide on who gets to be the jury or not. If you want to get an idea how this is done, I mean, seriously, scientifically, there's a TV show called Bull. It's on the same network as NCIS. It's usually at 9 o'clock on Tuesday night. Watch one episode of Bull, and that'll show you how, the whole jury consultation process and jury selection process. Some people are skeptical about the scientific qualities of jury selection, but some people like to do it or like to use it. Jury consultants have been hired in high-profile political cases and high-profile trials because they want to make sure they select the best jury. What do you think about it? Do you think that some person should come in and consult and help the selection of the jury? Do you think we can actually predict through just the simple questions that we ask how somebody's going to vote later on in the case? Again, I would watch Bull, and you'll have a really good idea of how that works. Some people have equated scientific jury selection with jury tampering and suggest that the integrity of the jury is undermined and compromised. What do you think? Jury size. Jury size, in some states, you can have 6 people in a jury. In a lot of states, it's 12 people. So it has no reasoning. It's more like a historical tradition. Juries are usually comprised of 12, but in Florida, they've had 6-person juries. Supreme Court said 12-member jury was not in the Constitution. So, but it cannot be less. This Baloo versus Georgia said it can't be less than 6. So you do have states that actually go to criminal trial with only 6. Florida, obviously, being one of those states. In a 12-person jury, there's been decisions that you do not have to have unanimity. That's probably based upon Supreme Court decision. But if you notice, a lot of states require it. So like in the recent Bill Cosby case, the jurors could not decide, even though there was a majority that wanted to convict them because there were 2 people, I think it was 2 people that held out. It was a hung jury. But there's some states where 10 would have been enough to convict them. If it's a 6-person jury, you have to be unanimous. Sequestration, it means that the jurors are isolated. So if there's a case, it's a high-profile case, a lot of media coverage. Bill Cosby was one of those. They would put them up in a hotel for the week so that nobody can get to them, so that they're not reading the paper, they're not watching the news, and they're not influenced. They're only going to be getting facts from the case itself. They don't want them hearing outside information. Sometimes that's good, sometimes it's bad. Sometimes you have people bonding, close bonding and making their decisions based upon influence from some other juror. You have groups that might form and problems that might develop from these groups forming. And it's also very expensive. Obviously, the recent Bill Cosby trial cost the county a lot of money, a whole lot of money, and a crazier amount of money, because they had these people, they had to bring in a jury from Allegheny County, Pennsylvania, because they felt that there was too much press in this area to have the jury here, and they put them in a hotel for the entire length of the trial. They had a whole lot of security because it was a seriously high-profile case. So it can be very expensive if you have to do that. Jury decision-making. Jurors are affected by quality and quantity of the evidence. Sometimes they're affected by stereotypes about crime. What do they think about crime? Attractiveness of the victim or defendants, which is really, pretty sad. Whether they've been a previous juror, so their previous experiences, and resistance, which is pretty sad. So, and this was probably in a rape or an assault case. If the jurors, think, well, she didn't resist enough, sometimes they might vote in favor of an acquittal because they don't think that the person put enough resistance, and that's not a good thing. That shouldn't be what it is, because if you're in a rape case, you don't have to fight the guy to show that you didn't want it to happen. All you have to do is say no. You can't study. We obviously can't study jury deliberations because they're all private, so nobody sees them. Certainly, the media likes to interview people afterwards and ask them all kinds of questions to find out what they were thinking. So, to that degree, you can study them, but you can't see it live. Sometimes people use mock juries and mock trials to try to figure out how the jury's going to get, make their decision. Again, that show Bull. They actually use mock juries that are set up. They call them mirror juries, that have people that have the same backgrounds and experiences to try to play the role of the jurors to see how they're going to think. Two types of deliberation: evidence-driven or verdict-driven. So evidence-driven, obviously, they're looking through the evidence piece by piece to come to a conclusion. And verdict-driven might be they already have an idea what they want, and they're looking at the evidence to prove or verify what they already think. Jury misconduct. People who are in juries, people have committed misconduct. Engaging in delinquency or lying to avoid jury service. So, pretending that you have an exemption, lying about it. Engaging in improper or prohibited behavior while serving as a juror. There's a case of two jurors who snuck off and had sex while they were jurors. Not allowed to have those types of relations. Talking to the press, doing other things that you're not permitted to do. It could be taking a bribe to make a decision. Discussing evidence with other people, reading or watching prohibited media. So if you're not allowed to watch the news and you watch the news, that could be misconduct. Drinking, alcoholic beverages might not be permitted. All right, so slam bang, that's all we have to talk about for judges and juries. Read your textbook, highlight before you take the quiz. Let me know if you have any questions. I'm going to cut this off right now because obviously it was very, very long, and hopefully it'll process properly since I'm out here in the woods and the Wi-Fi is not that great. So everybody have a wonderful day. Bye-bye.